The Sherman Antitrust Act of 1890 helped regulate monopoly industries in the 1800s, such as the oil and railroad industries. Even though railroad monopolies aren't as big of a problem in the United States as they once were, the impact of antitrust laws can still be felt today in the professional and amateur sports industry. Let's take a detailed look at the Sherman Act in the context of sports law. Under the Sherman Act, it is illegal to monopolize or attempt to monopolize a market for products or services. A monopoly occurs when one party or business has exclusive control over the market for products or services. Monopoly offenses can either be criminal or civil. Agreements to fix prices or wages and exclusive contracts that are in place to reduce competition are considered criminal violations under the Sherman Act. The Sherman Act is made up of two sections, Section 1, which applies to restraints on trade, and Section 2, which applies to a monopoly control of a market. The United States Supreme Court has held that Section 1 of the Sherman Act only applies to unreasonable restraints of trade. There is an emphasis on unreasonable restraints of trade because almost any contract or agreement between parties could be considered a restraint of trade.